Subcommittee will come to order. I ask unanimous consent that the chair be authorized to declare recesses during today's hearing. Without objection, so ordered. I also ask unanimous consent that the members not on the subcommittee be permitted to sit with the subcommittee at today's hearings and ask questions. Without objection, so ordered. We'll now proceed with opening statements. I'll go first. Today's hearing is going to focus on the General Service Administration's handling of the lease at the old post office building here in Washington. Owned by the federal government, the building is being leased to the Trump Organization and now houses the Trump International Hotel. This morning, we are joined by Ms. Emily Murphy, the Administrator of General Services Administration, and I welcome you to the committee and appreciate talking to you earlier. Administrator Murphy's in a difficult position. She is responsible for overseeing the Trump Organization's lease of the old post office building, and yet her boss is ultimately President Trump, and that presents a serious problem. It's one that could have been prevented if the president had divested from his business interest in the Trump International Hotel or put them in a blind trust like every modern president before him. Instead, President Trump is the single largest beneficiary of the Trump Organization's hotel in Washington. He makes money when people stay there, and he loses money when people don't. So let me repeat, President Trump is both the GSA's tenant and its boss, and that's an obvious problem. Perhaps then it's no surprise that Administrator Murphy's agency has refused to turn over documents that were subpoenaed by this committee that would help us determine, one, whether the president's following the Constitution, and two, he's complying with the terms of the lease. We know from dogged reporting that President Trump's D.C. hotel isn't going quite as well as he'd hoped. While it's being propped up by foreign governments, corporate executives, and lobbyists looking to curry favor, that apparently isn't enough because the Trump Organization has now announced it's looking to sell its lease. Administrator Murphy, as you likely know, last Thursday was the deadline by which initial bids to purchase this lease were to be submitted by potential buyers. The Trump Organization is asking for $500 million for this lease, which is by far more per room than any other luxury hotel here in Washington to date. That means that you're going to be overseeing the potential transfer of hundreds of millions of dollars into the pockets of the president and his family. Given the myriad of issues and concerns raised by the execution of this lease from the outset, I want us to make sure that the GSA and this committee have a clear understanding of the process moving forward and that we're not going to be repeating the significant mistakes of the past. What we want to know and what we want to find out in this hearing is if any changes could be made to the terms of the lease with the new tenant. Additionally, we need to determine the need for any new legislation to guide and oversee the outleasing process. But most importantly, American taxpayers deserve transparency. They need to know who's buying this lease. And above all, we need to seek information to ensure that it's not some foreign government. That arrangement would not only raise serious ethics questions, but could also potentially bring into question the Emoluments Clause of the Constitution and potentially threaten national security. Given that the GSA's Inspector General concluded last year that your agency ignored the Constitution, I put that in quotes, and has said that you're continuing to ignore the Emoluments Clause, we hope that we can ensure that going forward with the potential sale of this lease, we'll be abiding by federal law. Some of us believe that the Constitution matters. It's the law of the land, regardless of whether this administration finds it to be inconvenient or not. So I thank you, Administrator Murphy, for being with us today. I thank you in advance for being willing to answer our questions. And now I'll recognize Ranking Member Pence for an opening statement of 5 minutes.
Thank you, Chairwoman Titus. I want to welcome GSA Administrator Emily Murphy and thank you for joining us today. GSA has accomplished a lot in recent years across its portfolio. GSA saved federal agencies $7 billion in just fiscal year 2019 alone. The DOT headquarters purchase will realize significant savings over the long term. And GSA was part of the team to help stand up the Public Building Reform Board pursuant to the FASTA Act, which will realize billions of dollars in savings in the sales of unneeded federal property. But once again, instead of focusing on critical issues like those I mentioned or our crumbling infrastructure, we are here today focusing on bashing the president. We have other business before this subcommittee that is critical to the American taxpayer, including issues that fall under the purview of the GSA administrator. For instance, Ranking Member Meadows and I introduced legislation that would give GSA some of the tools needed to address the avalanche of expiring leases. We spend over $5 billion a year on leasing space. We should be focused on what we can do to ensure these leases are replaced with good deals and continue to reduce costs. We also have bills pending before this subcommittee to pilot the use of public-private partnerships to help address a backlog of GSA projects. We should be focused on solutions to address a backlog of GSA capital projects so we are not forced to resort to leasing because we cannot afford to do anything else. The Federal Protective Service is responsible for securing GSA's facilities. There is a reorganization happening right now involving FPS. But instead of focusing on how this reorganization may be impacting the security of people working and visiting federal buildings, we are holding our second hearing related to the old post office. Office of Management and Budget just approved the first round of high-value properties to be sold under historic and bipartisan legislation this committee drafted, the Federal Asset Sale and Transfer Act. But instead of focusing on that, we are questioning a project that turned a money-losing asset into a money-making asset for taxpayers, which was, I think that's about $9 million a year in savings. GSA, along with other agencies, had facilities damaged in many of the disasters that happened across the country in recent years. Where are they in fixing and repairing them? Why is that not a focus today? And instead of ensuring all GSA employees are focused on these and other critical issues, many of the GSA employees have had to spend their time responding to the majority's document requests, which can best be described as a partisan fishing expedition. Let's be clear, GSA has produced over 10,000 pages of documents in response to Democratic requests, over 30,000 if you include the FBI headquarters project document requests. Despite GSA providing rolling document productions following our hearing in September, the chair felt compelled to issue a subpoena. In response, GSA offered this committee an opportunity to go to the GSA and review the financial records submitted for the old post office for oversight purposes. This committee has had a long-standing bipartisan respect for the sensitivity of certain information, such as procurement-sensitive and proprietary business information. We know this information, if disseminated, can harm the interests of the taxpayer, as it would result in lower competition and increased costs because of the higher risk of doing business with the government. I agree you have to be able to conduct our oversight, and as I stated earlier, GSA has invited this committee to view the financial records for this purpose. But the majority would not take up GSA on this offer because the committee would not agree to one simple term: to not publicly disclose any of the private financial information attained in this document. This only confirms what we already know. This is not a legitimate exercise of the committee's oversight authority, but rather an abuse of that authority to harm the president politically. We spent our December hearing listening to witnesses argue that the current arrangement at the OPO violates the Emoluments Clause, and now that there are reports the hotel interest may be sold, that too, according to Democrats, violates the Constitution, even before it's happened. Outleasing historically has not only been supported by Congress, but encouraged. The Public Building Cooperative Use Act of 1976 and Section 111 of the National Historic Preservation Act were intended to encourage commercial, cultural, recreational, and other activities in federal buildings. The opioid lease itself was directed by Congress in legislation. Are there valid issues we may want to examine with respect to outleases going forward? Of course. There are many other issues we should be addressing here today. I hope today we can not only look at outleasing going forward, but other critical issues related to public buildings. I yield back the balance of my time. Thank you.
I would now recognize Mr. DeFazio for 5 minutes, Chairman of the Transportation Infrastructure Committee.
Well, I thank the chair, and in response to my colleague who just spoke from the minority side, we wouldn't be holding a second hearing here today if GSA had both followed the recommendations of its own internal watchdog, the Office of Inspector General, that concluded the GSA failed to consider the emoluments clause when evaluating the lease. And we wouldn't be here today if they were recognizing the legitimate oversight authority of this Congress. Now, what we're here about is the Constitution of the United States of America, and that's pretty damn important. Doesn't matter who's president. Your president, my president, anybody. But in this case, we would love to see the so-called legal memorandum that concluded that this lease does not violate the emoluments clause of the Constitution of the United States of America. And as I said, the OIG said it wasn't considered. They apparently have seen the secret legal memorandum, which we're not being allowed to see, that somehow concludes that either the President of the United States is not an elected official or is not benefiting from the lease. Now, I don't know which of those two conditions it is, but it seems that that's a problem. Now, and the gentleman carried on at some length about us reviewing in camera the financial documents with a restriction that in exercising our legitimate oversight authority to see whether or not the taxpayers in the United States are being made whole under this lease, that we would be bound to secrecy after viewing them. Now, I think the gentleman has sat through some of the hearings with Boeing. Even Boeing, a private, for-profit company, didn't try and impose such a restriction on us. In this case, we're talking about the government of the United States of America, a federal agency trying to impose such a restriction on us. That is outrageous. Absolutely outrageous. And, the only thing we've gotten from GSA that's meaningful is a letter that they forwarded from an attorney for the Trump organization in terms of why GSA wouldn't comply with the records request. That's a bit odd. It isn't even from the legal counsel at GSA. I think they do have attorneys. In fact, they have some sort of legal analysis, maybe, about this lease, which we can't see. But that letter, forwarded by GSA, questions our oversight jurisdiction, our legitimate need for financial records. So the question is, who is GSA serving here? Trump LLC or the people of the United States of America? That's why we're here today. Now, we're confronted with something of even greater import now, which is the potential sale of this lease. Let's just say that Vladimir Putin or one of his oligarch friends decides to buy the hotel for an outrageous price. Wouldn't that be interesting? Oh, well, what if it's the Chinese? Or what if it's bin Salman, who apparently helps hack phones of individuals who the administration doesn't like? Will there be a security review of this lease? Will the GSA refer it to CFIUS? Because Congress has said, buildings that are to be leased by the government in proximity to sensitive institutions, military bases, et cetera, and this isn't pretty darn sensitive, it is across the street from the FBI, it'd be a great place to do surveillance. Is a GSA going to go through a full CFIUS process? We will be asking those questions later in this hearing. We also asked GSA to conduct an audit. We asked last September, would you audit? And GSA has yet to respond to that. So the gentleman wonders why we're here today. We're here today to protect the interests of the people of the United States of America, the taxpayers of the United States of America, and the Constitution of the United States of America. That's why we're here today, no matter who's president. I yield back the balance.
Thank you, Mr. Chairman. Recognize Mr. Graves for an opening statement.
Thank you, Chairwoman Titus, and I want to thank the administrator for being here today. Normally, when we invite the heads of an agency to testify, it's to discuss critical issues facing the agency itself. But today, here we are. We called the administrator in to focus primarily on one project, the old post office, and the outleases that generally only account for less than 1% of all the GSA leases that they manage. As was pointed out, under this administrator's leadership, GSA has saved the federal agencies and taxpayers more than $7 billion in 2019. And GSA has closed the deal on the purchase of the DOT headquarters building. It's managed major renovations at land ports of entry. GSA's role in implementing the Federal Assets Sale and Transfer Act is going to save billions by selling and redeveloping underused federal assets. This is the second hearing on the old post office, a project that was directed, a project now being criticized because of the lease and the terms in the lease, and the project was directed by Congress through Democrat legislation and awarded and negotiated under a Democrat president. And yet here we are trying to slam this president for things that are in a lease done under the last administration. And it's unfortunate that the desire to impeach the president runs so deep that even issues related to public buildings have become partisan. We may from time to time disagree on projects and priorities, but ultimately our goals have been the same: to ensure that GSA is a good steward of the taxpayer dollars. And after thousands of documents produced and the offers by GSA to make accommodations for the committee to request those requested financial records for the OPO, which, by the way, have yet to be taken up by the committee, the majority still accuses the GSA of obstruction. And for what? Because the Democrats claim that the lease is going to violate the Emoluments Clause, which is an unsettled area of the law, which should be sorted out through the courts and not by us here. So let's get back to real work with all the time and effort that's put into investigating this one lease. We could have worked together to develop solutions to some of the critical issues that are facing management of our public buildings and other infrastructure, for that matter, throughout this country. I hope we can talk about some of those other pressing issues and the good work that the administrator is doing since coming on board. And with that, I yield back.
Gentleman yields back. We'd now like to welcome our witness, the Honorable Emily Murphy, Administrator of USGSA. We're glad to have you here today. We look forward to your testimony. As you can see, we're anxious not only to learn about what has happened, but going forward, what will happen with the sale of the lease. Without objection, our witness's full statement will be included in the record. Since your written testimony has been made part of the record, the subcommittee requests that you limit your oral testimony to 5 minutes. So please go ahead. Thank you very much.
Good morning, Chairwoman Titus, Ranking Member Pence, Chairman DeFazio, and Ranking Member Graves, and members of the subcommittee. Thank you for the opportunity to testify. It's actually a particular honor for me today because I get to testify in front of my former boss, Mr. Graves. GSA's mission is delivering value and savings in real estate, acquisition, technology, and other mission support services across government. I'm proud to say that in my 2 years as administrator, we've saved federal agencies $14.5 billion. We're able to do this while improving the agency culture and saw our best places to work rating improve to its highest score ever. Our success is based on our partnership with suppliers, customer agencies, and Congress. This subcommittee and GSA have worked together to more efficiently and effectively manage GSA's 368 million square feet of office space. This is saving taxpayers billions of dollars. While I'll talk about GSA's document production, I do hope I'll be able to discuss some of GSA's major initiatives. It is crucial that we work together to invest in GSA's own portfolio and address our repair and maintenance backlog. First, GSA has provided the vast majority of what this committee has asked for. Regarding the OPO lease, GSA has provided more than 3,700 documents totaling more than 10,000 pages. This is only part of the 7,000 documents and nearly 30,000 pages GSA has provided to this committee since I became administrator in December of 2017. With regard to the document requested regarding the OPO lease, it's my understanding that GSA has provided all documents with 2 exceptions. The first category includes confidential financial records provided by the tenant pursuant to the terms of the lease. Prior to October 24th, GSA was unable to provide those materials without violating the terms of the lease. However, following the receipt of the committee's subpoena on November 12th, GSA offered to make the unredacted records available for the committee's review, provided the committee agreed not to publicly disclose the information contained within the records without GSA's consent. The purpose of this condition was not to resist congressional oversight, but rather to preserve the confidentiality of proprietary information provided by those who seek to do business with the government. If tenants and suppliers come to believe that GSA will not protect their confidential information, then it will be much more difficult and expensive for GSA to acquire space, goods, and services for our federal customers. While the committee has not yet agreed to those terms, I'm hopeful you will soon agree, as our offer to review the documents still stands. Second, GSA has not produced agency legal opinions regarding the OPO lease. These documents are highly deliberative in nature and contain attorney-client communications that implicate core confidentiality interests of the executive branch. It is a long-standing practice of multiple administrations of both parties to protect the confidentiality of legal advice. In the meantime, GSA is investing in its own real estate, most notably by modernizing and expanding land ports of entry on the northern and southern borders. 2 such active projects are the expansion of the land port of entry in Alexandria Bay, New York, and in Calexico, California. Congress has recently funded phases of these projects and passed the USMCA. This makes it especially important that GSA-controlled LPOEs on both of our borders are modernized for the future. Additionally, GSA will be working with this committee to address more than 100 million square feet of expiring leases in the next 5 years. These are worth more than $60 billion. We cannot let this opportunity for savings slip past us. Finally, there's a significant issue that harms GSA's ability to invest in its existing buildings and construct new facilities. GSA lacks the ability to access the full revenues collected in GSA's Federal Buildings Fund. GSA charges federal agencies rent for the space they use and then deposits that rent into the FBF. Congress exercises control through the appropriations process. It sets annual limits on how much of the fund balance GSA can spend. Since 2010, GSA hasn't been allowed to spend what we've collected. As a result, the balance in the Federal Buildings Fund has continued to grow and is now more than $8 billion. At the same time, we have a $7 billion backlog for repairs and alterations. This backlog will only get worse. The average GSA building is over 50 years old. Our aging buildings can be valuable assets for decades to come, but not if we fall behind on needed repairs and alterations. To address this vital issue, I would ask that members of the subcommittee advocate for full funding of GSA's forthcoming FBF request. This will allow GSA to make critical maintenance and repair investments in existing infrastructure, as well as to construct new facilities, allowing the federal government to better carry out its mission. With that, I again thank the committee for their time today and welcome any questions.
Thank you very much. We appreciate the testimony. We will now move on to member questions. Each member will be recognized for 5 minutes, and I'll start by recognizing myself. Just to ask some questions going forward. I want to focus on going forward. In October, Eric Trump, who's your boss's son, confirmed that the Trump organization was considering selling their lease of the old post office building here in Washington that your agency oversees. According to marketing material obtained by the Washington Post, last Thursday was the deadline for initial proposals to purchase the 60-year lease from the Trump organization, which it hopes to sell for as much as $500 million, as I mentioned. So I would ask you, has the Trump organization shared with GSA the names of potential buyers of the lease?
To the best of my knowledge, no, they have not.
Section 15.3 of the lease allows for the owner of the lease to sell it to a qualified transferee. Can you tell us what a qualified transferee is? What does that mean?
So under Section 15 of the lease, there's a 7-part test for a qualified transferee. It goes towards the character of the party. It goes towards their financial responsibility, their ability to actually pay us the rent, their past history of maintaining historic property. I'd be happy to provide you with the clause of the lease.
Well, how, can I ask how GSA is going to evaluate the potential leasees or lessees, or will you do this for the whole list of them if they give you 3 or 4 that might be potentially qualified? And what do you consider as you come to the determination that they're qualified? You heard the chairman mention, could the Saudi Arabian Crown Prince qualify? He's bought a $500 million yacht and a $300 million French chateau. It sounds like by what you just listed, he might be considered a qualified transferee. Or the China Construction Bank, for example, might be able to make a profit and they could apply to purchase it. Could you give us an answer of how you consider applicants like that?
So I want to answer the first part of your question first, which was, do we anticipate that we're going to get a slew of offers to evaluate? And right now, we don't know if we're going to get a single offer to evaluate. That's going to be up to the tenant once they've completed their negotiations. At that point in time, they would give us who they're proposing as a qualified transferee. Only at that time would GSA's role begin. So at this point in time, anything would be hypothetical. That said, not knowing what offer we're going to get, it's very hard for me to give you a hard and fast, well, we're going to do this or this. We're going to evaluate the offer we get, and we're going to do the right thing with that offer.
So they make the first determination, they give you the name of their potential buyer, and that would be the one you would evaluate.
That's correct, ma'am.
The Constitution explicitly forbids the president from accepting emoluments or payments from foreign entities. Would you rule out any foreign entities as an applicant if that's what's presented to you?
So at this time, I want to be very careful in answering this question because there is litigation pending on the emoluments clause. It was filed before I ever began at GSA, and the Department of Justice has ruled that it's publicly stated and argued that there is not an emolument at this point. Given that I do not know what the offer is going to be, I don't want to make a judgment on that. It would be very improper for me to weigh in on the emoluments clause. That said, this is going to be my first time of having that issue come before GSA when I've been in charge, and we're going to do the right thing.
Well, let's just take this away from the post office and talk about future outleasing. Do you think it is appropriate to outlease federal buildings to foreign entities?
I think that we would, that under the current laws, we have to follow the current requirements that are in place for that in Title 4041 on how we're handling our outleasing. I am unaware of any outleases we have with foreign entities at this time. And I know that we would want, that's going to be governed by the terms of our leases themselves.
Who in your agency is responsible for doing this evaluating?
Of this specific lease or in general?
Well, both. Is it the contracting officer?
For any specific lease, any individual lease, it is the contracting officer who is vested with that authority by law. As we look at policies across the General Services Administration, we have an assistant commissioner for leasing who reports to the Federal Buildings Commissioner, and working with them, we also make sure the Public Buildings Commissioner, we work with them to make sure we've got the right policies in place with General Counsel's office, with other support offices.
Does the GSA General Counsel get involved in that?
So the General Counsel in the prior administration got involved in December of 2016, and that was the individual, so it was the Obama administration's General Counsel who made the decision not to go to the Department of Justice on...
I'm talking about the future selling of the leases, not the past. Let's talk about the future.
So I think in the future, we're going to have whoever we need to be involved in that, in evaluating the lease involved. We have there's a lot of very solid career attorneys in GSA.
So what I'm hearing you say is that there aren't any rules, there aren't any guidelines, anybody's eligible to apply, and you'll worry about that down the road because nothing is in place.
No, what I'm saying, ma'am, is that the lease itself governs how I act. And
can the lease be changed with a new tenant when they sell the lease?
We could enter into a bilateral negotiation with that tenant.
Who decides that?
That would again be something that we would need to propose to the tenant, or the tenant could propose to us. It would be a separate It's a separate process, though, from that provision.
Seems to me we need to
Section
put in place some guidelines for that consideration going forward. My time is up. I now recognize Mr. Pence, but we may come back to that.
Yes, ma'am.
Thank you, Chairwoman Titus. Administrator Murphy, following our first hearing on the old post office last year, Chair DeFazio and Subcommittee Chair Titus sent a letter to you in October reiterating their request for financial records related to the OPO. According to your testimony, GSA has provided more than 3,700 documents totaling more than 10,000 pages to the committee on this topic. You continue to explain today that the only outstanding documents fall into two categories. First is legal opinion, and it is a long-standing practice of administrations not to disclose internal legal advice. And the second category includes confidential financial records, and that's included in the lease. On October 24th, Chair DeFazio and Titus issued a subpoena for these documents, the first T&I subpoena issued in almost a decade. In your testimony, you note that prior to the subpoena, GSA was unable to provide confidential financial records without violating the terms of the OPO lease. I am holding here two letters that you sent in response to Chair DeFazio and Titus on November 12th and 18th, offering the committee an in-camera review of the requested financial records and provided the committee does not publicly disclose the information, and with an explanation as to why you had taken that route. Administrator Murphy, am I correct in my understanding that GSA offered not once but twice to set a time for the committee to review the relevant financial records?
Actually, Congressman, it's more than twice because there were also phone calls between the respective staffs where we've made that offer, and it is an outstanding offer. We'd be very happy to have the committee come in and review those records pursuant to those conditions.
So I think you just answered my next question. Did any member of the committee take you up on that offer?
No, sir.
Okay. Is this offer still open to come and
Yep.
review
Yes, sir.
the financial information that
Yes.
we've been discussing in the previous hearing?
Yes, sir.
In your testimony, you said, and I quote, GSA's offer was not to resist congressional oversight, but rather to preserve the confidentiality of proprietary information. Can you explain why the GSA, and you touched on it a little bit, takes this position and why the security of this information is important?
So, sir, we have 68 billion contracts. We have another 8,000 leases and 600 outleases. If the parties that we're entering into contracts with can't trust us to live up to our side of the bargain, then they're not going to do business with us. And I am a firm believer that competition is good. And so I want to make sure that we're creating at GSA an environment where we do the right thing, we live up to our obligations under the contracts, and that we're encouraging competition so that we get the best results for the taxpayer.
So you have a contractual obligation here to not share that information. But how could releasing that information make it more difficult to do business with GSA?
Well, because I think that if our tenants and other contractors see that we're not as good as our word, we're not living up to the bargain that was struck in 2012, they're not going to want to do business with us in the future. They will walk away from doing business with GSA.
And to go and change an existing arrangement such as this would require both parties to agree to that change. Is that correct?
Yes, sir. And I believe Chairman DeFazio referred to a letter that was sent to this committee. The reason that letter was sent was because GSA, prior to the issuance of the subpoena, had actually asked the tenant organization to consent to disclosure, which was one of the ways we could disclose those documents under the lease. They declined to do so, and we shared that information with the committee in an attempt to be transparent.
So as a person that has been involved for decades in real estate, I can relate to what you're saying about if I strike a deal with another party, I really don't want that deal shared with just anybody, or even if I'm going to bid on something, I think it's improper that my offer or my terms and agreement are just shared with the public as well. So I support the position that GSA has. I think it's good business practice. It's a way to carry forward in the future as well. Thank you, and I yield back.
Gentleman yields back. Just to follow up on that, you mentioned how many leases you oversee. How many of those are outleases? How many of those are outleases to elected officials? And how many of those outleases involve foreign governments?
I believe we have a little over 600 outleases, that they're worth a total of $28 million. I think that only 5 or 6 of them are for more than 20% of a building, so they're the
5 or
vast majority-
6.
Yeah, that's the vast majority of the dollars. The majority of our outleases are for parking spots.
And how many are to elected officials?
So the only one that I know that could be construed as to an elected official is the one we're discussing today.
And do any of those involve foreign governments?
Not that I'm aware of, ma'am, but I.
Okay, so this is an unusual circumstance. I think we need to point that out.
Thank you, Madam Chair. We have, at the earlier hearing, revealed correspondence between the contracting officer and the president's daughter. And one of them, in mid-November, just after the election, he basically stated that there was absolutely no concern about emoluments. Isn't that a bit unusual that this unsettled technical legal issue regarding emoluments and a personal relationship or attempt at a personal relationship, soliciting, getting together for coffee and other things, isn't that a little bit unusual? Wouldn't a contracting officer consult with counsel, and wouldn't a contracting officer act a little bit more at arm's length from the tenant or the tenant's daughter?
So I believe that you're referring to the email that was in the paper about a fair bit of nonsense, sir? Is that the one that you're?
There were a number of, there was
I
an
want to make
email
sure
exchange. Yeah.
I think that's exactly why we make sure that our contracting officers work in partnership with our general counsel's office and with others to make sure that they're not operating alone. I know that the IG has actually reviewed the decision-making process and found that there was no political interference in that decision-making process. They found that they disagreed with the decision in December of 2016 to not consult with the Department of Justice, but that decision was made long before I joined GSA.
So you think that the contracting officer, by stating this before they had an opinion from legal counsel and having attempting to have a more personal relationship with the tenant, is all just sort of normal conduct by GSA?
I wouldn't use those words to construe it, but I mean, my job as the administrator is to make sure that the decisions themselves are not made in vacuums.
Right. Would you consider replacing this contracting officer before the hotel lease is transferred?
So the contracting officer you're referring to is 7 levels down in the organization from me, sir.
Yeah, well, you would have the authority to reassign him, I assume.
And I think that my doing so and my getting involved in micromanaging which contracting officers are assigned to which projects would be my putting my finger on the scales, which I've tried very hard not to do.
Okay, so you're not concerned. Fine, you're not concerned about his conduct. Let's move on to the foreign ownership issue. In 2018, Congress expanded CFIUS jurisdiction to include proposals from foreign purchasers to lease or purchase real estate near sensitive U.S. government properties and military installations. Would you agree that this hotel is in a sensitive place since it's across the street from the FBI?
I want to be careful in my saying that I believe it's in a sensitive spot versus whether that meets the definition of CFIUS. I am not a CFIUS expert.
Right,
If
but
it's
let's
a
just
CFIUS
say your
issue-
personal opinion. I mean,
But
my
if it's a
personal
CFIUS
opinion is
issue-
it's across the street from the FBI. Kind of what Congress wants here is CFIUS to review this. Would you ask for a CFIUS review?
If a CFIUS review is warranted, I will ask for a CFIUS review. Again,
Okay, and under what conditions would it be warranted?
it's going to depend on what offer, if we receive an offer from the tenant to substitute a qualified transferee, it would depend on what that offer is. So we're several ifs away from us ever receiving that. And again, it's not an area, as you pointed out, where it's GSA's determination. That would be one where we would talk to the Department of Treasury.
Okay, if a CFIUS review is initiated, will you wait until that review? There is a timeline on how long you have to approve the transfer of the lease. What happens if CFIUS takes longer than your timeline?
Sir, we're going to do the right thing. You're asking me about hypotheticals here that haven't even been
Well,
begun to
it's a
occur.
pretty important hypothetical given the location. Now, gentleman, carried on a bit about us reviewing the records and that. If we had followed your conditions, you, a federal agency, regarding this building, we would not have been able to pursue issues that are very pertinent to the problems with the death of 346 people in the Boeing MAX, because we received hundreds of thousands of pages of documents, every single one of which was stamped proprietary. But we were able to negotiate with Boeing, a private for-profit entity, that we could release such documents, and some of which have led to some revelations and changes at that company and potentially changes in the law. So you think it's reasonable that we can come in and look at the books, but we can't talk about it. Even if we find extraordinary improprieties, we can't talk about it. You think that's reasonable, yes or no?
May I
No,
answer a
no,
little
just
bit
yes or
more?
no, yes or no. You think that's reasonable?
I think our offer was a first attempt at accommodation, and that if we see those documents, it would then give us the ability to further decide whether there's a way to further accommodate your requirement.
The
When I was a
House counsel
professional
advised
staffer,
us that your offer was unacceptable to take that restriction. I just say that.
I
Now,
was a House staffer, working for committees doing oversight, we did accept similar restrictions.
right. Now, GSA's watchdog, the OIG, concluded that you failed to consider the emoluments clause when evaluating the lease, and they recommended that you revisit this issue. Are you doing that?
So, sir, if I could read you the IG's recommendation, I think it's very brief and I think it's pertinent. What they recommended was that before continuing to use the language, GSA determine the purpose of the interested parties provision, conduct a formal legal review by the Office of General Counsel that includes the foreign and presidential emoluments clauses, and revise the language to avoid ambiguity. What GSA agreed with that recommendation as a prospective recommendation for future contracts. What we decided was that based on the IG's research and our research, based on the IG's research, that the
So you didn't need to
clause was-
revisit it in this case because of a secret legal document which you also refused to disclose to the Congress. And how could that, how is it that a determination on emoluments regarding the President of the United States in this lease would discourage future transactions by GSA with private entities? That doesn't make any sense. I don't think we're going to have another president who has a outstanding outlease with the GSA. So how can you say that it is right and proper that you withhold from us this critical document that determines that the president and this lease somehow do not violate emoluments? And again, the pertinent language is, an elected official of the United States of America shall not benefit. Now, he's elected, I think, and I guess he's benefiting. So why can't we see that document?
So I apologize, I think you're conflating the two reasons we're giving. So we're not providing the financial reasons.
I get that, but you also,
legal
there's two
reasons.
things that are outstanding. You gave us 10,000 pages of drivel, including, audits by the tenant itself, who was allowed to self-audit, which even have blacked out the name of the person who signed the cover letter, which is all we got. So that's, I just find that unacceptable. Thank you, Madam Chair.
And we've allowed a little overtime, so we'll give the same indulgence to you, Mr. Graves, if you have some questions. Mr. What happened to Mr. Graves? Oh, well, it's Ms. Miller then, I'm sorry.
Thank you, Chairwoman Titus, and thank you for being here today. It's very important to acknowledge that outleasing plays a crucial role in sustaining long-term historic building longevity, and it is a critical solution to repairing the physical condition and futures of these buildings for the general public and to the communities where these buildings are located. How many historic buildings does the GSA oversee?
About a quarter of our own portfolio is historic buildings. We've got about 1,600 in federal assets, so it's a little bit over 400, between 400 and 500 historic buildings, ma'am.
400 to 500, very important buildings. In your opinion, how critical is the outleasing process to these historic buildings?
So it's absolutely critical because it allows us to go into these historic buildings and make sure that the current building we're talking about, we had $200 million in investment that was made in bringing that building back up to standard so that it will continue to be a asset of the federal government for years to come. And the revenues we're getting from that allow us to invest in other historic buildings.
Absolutely. We are currently focused on the big outlease projects like the old post office and the old tariff building. While these outleases are important, can you describe some of the other various types of outleases that the GSA oversees?
So our largest category of outleases is parking. Then we have also antennas, which really help us provide rural broadband by having antennas on our roofs. We have credit unions and coffee shops in our buildings. We allow for some filming of television shows and movies that take place. And some buildings, out of the old Customs House in Louisiana, they use it frequently in NCIS LA, I believe. Yes. So all of these are ways that we're continuing to make sure that these buildings are preserved, we have revenue coming in, and frankly, it also mitigates against having vacant space in the federal portfolio.
Absolutely. In your testimony, you mentioned that it is the GSA's goal to update and modernize facilities. Are these GSA facilities on the right track towards completion and ready to promote trade, given the impending signing of the USMCA?
So I think that the two LPOEs I mentioned are on track. We're going to be so we've asked for funding for both Alexandria, or we've received funding in 2 phases for Alexandria Bay and for Calexico. I believe that there's going to be one more request coming on Calexico West. So those are moving forward. I would say, though, that over our entire portfolio, as I mentioned, we've got a $7 billion backlog for repairs and maintenance. And it's led to some, in the chairwoman's district, we had a courthouse that didn't have a working fire alarm for a period of time. Now, we've gotten funding now, and we're addressing that, but just yesterday, a pipe burst there. And so that courthouse is not working again today, and we hope to have it fixed by the close of business today, but these repairs are vitally important.
What is keeping you from doing the repairs if the money's there?
Our appropriations process is such that even though we collect rent, we can't spend the money unless we're authorized or appropriated those funds again by Congress. So we've got about an $8 billion surplus in the Federal Buildings Fund.
Well, it sounds to me like we need to work on that as well. And I will yield back the remaining time to Mr. Pence.
Mr. Pence. Mr. Pence.
Just to clarify, so we can go in and take a look at this agreement, right? And get the specifics instead of kind of guess what may or may not be in that. Is that correct?
You're welcome to come in and see the financial records, the legal memorandum, no, but the financial records we're happy to.
Okay. It's kind of my understanding, I could be wrong, that Boeing had a non-disclosure agreement which they waived in their agreement with the government, and that's why that information became public. Let me just be, how often do you have non-disclosure agreements in leases?
I don't think it's uncommon to have these in our leases. In fact, there are some that are required by statute, requiring the Procurement Integrity Act and others that require we protect that financial information, sensitive business information of our customers.
Last question, when was this lease signed?
2012, sir.
2012, thank you. I yield back.
Thank you. If Boeing can waive a non-disclosure, you would think the President of the United States would find it in the public's interest to do the same, but apparently not. Who's next? Ms. Davids would be recognized for 5 minutes.
Thank you, Chairwoman. Administrator Murphy, I wanted to ask you a bit about the process and what things will look like going forward. I think that the folks in my district really just want to make sure that we're managing our resources and spending the taxpayer dollars that they're sending to the federal government well. And so as we're getting into this process of finding a new purchaser for the Trump Hotel, and we're going to be forward-looking on this. How do you think the process that you followed before, that the GSA followed before, worked? Do you think it was a good process? Do you think it was effective? Was it a failure? Was it somewhere in between that?
Are you talking about the 2012 process?
I think the process as a whole, whether or not, I guess I'm wondering, do you think this has been a good use of our time and energy?
So I think that we took a building that was costing taxpayers $6 million a year, and at this committee's direction, converted that building to a property that's generating about $250,000 a month for taxpayers. So where we ended up having a substantial amount of historic preservation take place to make sure that building remains in good condition into the future. So I think that's overall been a very good, and it was actually a bipartisan directive from Congress for GSA to do this long before I was there. So
Okay.
I don't take any credit for it. I think it was
So-
a wonderful idea. I believe that your colleague was actually the one who sponsored
Thank you. So as you engage in out-leasing, again, of 100% out-leasing of a historic building, are you going to, do you think that the lease will look the same? One of the things that I'm wondering about, I haven't seen all of the provisions of the lease, but it seems to me that there might be room for provisions that maybe address a significant change in circumstance. It is not unusual to have assignment provisions. It is not unusual to have change in ownership provisions. And in the case of a building that is owned by the federal government, do you foresee having any new provisions that might address the potential for having someone who was not an elected official becoming an elected official, and making sure that we're not having to take up all of this time doing all of this oversight?
I think that's something we'd love to work with this committee on, trying to craft the appropriate language and looking at those. I'd point out, we only have, I believe, 5 or 6 outleases where more than 20% of the building is outleased. So this is a very rare circumstance for GSA.
Okay, it's a rare circumstance, but you also indicated that this was absolutely critical to maintaining and addressing the historical buildings and that sort of. You said there were 400 to 500 historic buildings. I just want to make sure it's critical or it's not critical.
So it's there are 2 questions. Is the funding we receive from outleasing great for our historic preservation? Yes. As a portion of GSA's entire portfolio, though, these 600 outleases, I said only 5 or 6 of them are more than 20%. The entire portfolio of outleases are only about $28 million a year.
Okay,
So-
so I just want to make sure that as we move forward, that you all are really forward-thinking about the way that you do this leasing process when you're talking about outleasing to private entities, and that you're making sure that, one, there's auditing that's happening, because when the person was here before that I spoke to from GSA, he was supposed to be running the program and was completely unaware of whether or not they were doing auditing. And then 2, making sure that this is actually, if it is critical, that's great, but making sure that we're forward thinking about what potential might come up. I think there are a lot of professionals who have seen a lot of circumstances in the GSA, and that we probably could have avoided this had the lease been drafted better. And then the last thing, I guess I just want to know, like, do you think that this is so critical that it needs to continue, or do you think that we should look at selling these buildings outright and not doing this?
I think that selling some of these historic buildings outright would mean that they would not remain historic, that would be a loss to the government. We are looking and we've worked with the FASTA board and with others on trying to sell properties that are not, that are underutilized or unused, so that we can start expediting the sale of those and get those off the books.
But that are not historic buildings?
But they're not historic buildings.
Okay,
yes.
so we should definitely make sure that we're holding on to our historic buildings
I think
and maintaining them.
I think it's a cost-benefit analysis of the historic building, the expected return on investment from keeping that building, the amount of repairs that are needed, whether we can find a suitable tenant for that building. And so I think that there are multiple factors that go into that, but generally, some of these buildings are beautiful, and the
Yeah.
thought of losing them is sort of heartbreaking.
Yeah, I agree. Okay, thank you very much. I yield back.
We'll now recognize Mr. Palmer for 5 minutes.
Thank you, Madam Chairman. I want to go back to the question my colleague just raised about being good stewards of the taxpayers' money. Again, for the record, you assert that prior to the Trump organization taking possession of this property and converting it to a hotel, we were losing over $6 million a year in taxpayer money. Is that correct?
That's what I understand, sir, yes.
Okay, and you also asserted that the Trump Hotel now generates $250,000 per month in revenue. That's $3 million a year.
Yes, sir.
And for those who are math challenged, that would indicate that the taxpayer benefit would be somewhere between $9 and $10 million a year, given the losses that were being incurred.
Yes, sir.
Would you agree that that's a positive for the taxpayers,
I believe so, sir.
even for those who are math challenged?
Yes, sir.
You would agree. I think so too. The GSA is audited. Is that an independent audit or a self-audit?
Yes, we have an independent auditor who comes and reviews our.
For those who dispute this benefit to the taxpayers, would you provide to this committee a letter from your auditor that, without violating any of the privacy requirements, that simply shows that the GSA is getting a return of $3 million a year?
I'm happy to ask the auditors for that and provide it to the committee.
I think, particularly if it's an independent audit, a reputable auditor, that should be sufficient to show that this is a substantial benefit to the taxpayers.
Yes, sir.
If you could do that, I would appreciate it.
Yes, sir.
The GSA has also offered to provide Congress, this committee specifically, access to the documents that will answer many of the questions that are being raised. And the only qualification that you assert is that the documents can't be made public. Is that an accurate assessment?
Did they not be made public without our prior permission? Yes, sir.
Without your prior permission. And you've made that offer several times.
Yes, sir.
Yet this committee has declined that offer.
They have not accepted it yet. I'm hoping that they're going to accept it at some point.
I think, frankly, we should accept it. And if there are people who have trouble reading financial reports, could the GSA provide some people who could walk members of the committee through that and explain it to them in simple language?
I'd be happy to make that those experts available, sir.
That would be greatly appreciated. And hopefully there will not be any leaks that would violate any of the privacy agreements, and that we could reach an agreement with GSA on what could be released. With that, Madam Chairman, I'll yield back. I'll yield to Mr. Pence.
Thank you, Madam Chair. I just want to kind of make some points, and then you say that's correct or that's incorrect. So in 2008, the OPO lease was directed by Democratic legislation. Is that correct?
Yes, sir.
Okay. And the law required this committee to receive a report before the lease was signed. Is that correct?
I believe so, sir. Yes.
And that report was received in 2013. Is that correct?
That sounds correct. Again, that was before I came to GSA.
Okay.
Yes.
And there were no objections to the provisions that were presented?
None that
the
I'm
committee.
aware of. No.
Okay, thank you. Yield back. I yield back to Mr. Palmer.
Yeah, there is one other thing that I wanted to raise. In the last hearing, Madam Chairman, it was the chairman of the full committee, Mr. DeFazio, indicated that there was a meeting with a GSA official that he was informed of, that via phone call and by email. I asked that the information from that meeting be provided to the committee. That has not been provided as of this date. I would like to get that information if possible. I think you agreed to do that. Well, the question for the witness is, are you aware of a meeting between members of this committee and GSA?
So I believe the meeting that's being referenced was a meeting that took place in December of 16 between the deputy PBS commissioner and some members of the Democratic staff here. I've asked about that meeting. It obviously took place before I was at GSA. I was actually still working on the House side at that point in time. And I've received contemporaneous emails, accounts of what took place in those meetings. I'd be happy to share that with the committee, but
Would you provide that, those contemporaneous notes to me? I don't know if any other members of the committee would be interested, but I would definitely be interested. I yield back.
Madam Chair, may I just clarify? I have no objection. That was a House staffer on this committee, Elliot, and also a Republican staffer was present at the meeting. And so this was no secretive meeting. There were no members of Congress there. We were raising questions about emoluments, which GSA initially said was a big problem. And then, later they changed their mind. So we will, whatever she can provide, would love to have.
Okay, thank you. According to Mr. Palmer's math challenge, the taxpayer would have gotten $27 million from the hotel. If Mr. Trump sells it for $500 million, how much of that will go to the taxpayers?
So again, the lease itself governs how the proceeds of the sale are done.
What would that be? What would that come to?
I don't know the specific.
I think it's
division.
zero.
No, I don't believe that that's correct, ma'am. I believe that the lease does provide for the taxpayers to receive some portion of that.
Maybe you can find the answer out
I'd be
for
happy
that.
to get back to
Okay,
you.
well, now we'll recognize Ms. Norton Holmes.
Thank you, Madam Chair. This hearing on the Trump Hotel is of special interest to me since it was my bill that finally got this hulk of a building from which the federal government was earning nothing, in fact, losing money. Finally got this bill through. I was in the minority, but the fact is that we worked together with the Republican majority. Before I get to that, could I ask you something, another question about GSA's present posture of moving the status of these federal agencies, though serving the District of Columbia Court Services, Administration, Pretrial, and Public Defender. All of these agencies have been kept with a synergy with the other side, the Metropolitan Police Department, the various actors on both sides have been kept within a certain short distance from the courthouse because they can be called and the courts do not want delay. But GSA is insisting upon moving the public defender more than a mile away. The U.S. attorney is 4 blocks away. That breaks with long history. So what's the rationale for moving the public defender further from the courthouse than the U.S. attorney?
Congressman, I'm not certain. I'm not familiar with the situation. I'd like to have the opportunity to look into it and come back and brief you on it, if that would be
I'd
possible.
ask you to get back within 30 days so we can understand your rationale.
I'm sorry, I missed the,
Get back within 30 days so we can understand your rationale.
of course, yes.
Now, as I indicated, the old post office was my bill. My friends on the other side talk about benefit to the taxpayer. Of course there's a benefit to the taxpayer, but the question is how much benefit to the taxpayer? There's no benefit to the taxpayer if the hotel doesn't benefit, it doesn't also benefit at this point, the Trump Hotel. So the Trump Hotel, the Trump organization wants to sell the lease. That suggests that it is not as profitable for them as they desire and expect. What does that tell you about how the lease should be handled when it goes to a new party?
So GSA's.
Do you know why they want to sell the lease?
I don't know, and I've not had any conversations with them about that.
They won the lease in a very competitive process. They paid millions of dollars to upgrade it because it was a historic property, and presumably made it profitable. But GSA should be concerned that so soon after, in fact, in a competitive process, getting the hotel, they want to outlease the hotel. Have you, in deciding how to handle this matter going forward or similar matters, have you studied this matter enough to know whether or not this was worth it and what to do as they outlease to another party who may have the same problems? Or did these problems develop after he became president? Did that have anything to do with whether or not the property was in fact being leased? Of course, he wasn't president when he won it. But is that perhaps the reason that the hotel is not making enough money for him to want to keep it?
So I wouldn't want to speculate as to why the tenant is making any business decisions. What I'm concerned with is that GSA is receiving its rent each month, that the property is being properly maintained, and that GSA is listed appropriately on the insurance certificate. If and when we're presented with a proposed qualified transferee, those will be among the questions that the lease requires that we ask also. Would the proposed qualified transferee have the necessary assets?
The other side talked about the benefit to the taxpayer. I'm trying to decide whether there could have been more benefit to the taxpayer. Suggests that we are not getting the benefit we expected because the Trump organization wants to get rid of it. Sure, they made some profit, but they would not want to be getting rid of a very profitable property unless it fell below their expectations. If it falls below their expectations, then the government is not getting what it expected from the property either. And that is the question I have for you. Are we getting what we expected in dollars and cents from the outlease of this property to the Trump organization? And how do you make sure that the government gets the profit it desired when it outleased it to the Trump organization?
So the government is currently being paid. We are being paid every month. I believe it's the 5th of the month we receive our rent payment. Our rent payment is due regardless of profit or loss. We get paid. And that's what GSA's concern has been, because that's how we protect the taxpayer. If we're asked to look at a qualified transferee, we would look at whether or not that transferee has the necessary assets to make sure that the taxpayers will continue to receive that payment.
Thank you, Madam Chair.
Thank you, Madam Chair, and still morning to the Administrator Murphy. I want to begin saying thank you for your involvement in the rebuilding process in Puerto Rico as we continue to face the recovery process from the hurricanes. And I do know, as per our conversation, that you're going to be visiting the island during the next weeks regarding many of those buildings that were not prepared for hurricanes or either earthquakes, and GSA is doing the investment to put them to withstand that situation. So thank you for that and for the visit to the island. I've been reading about this. This is not the first hearing we got about this hotel. And actually, you've been saying time again and again that this was approved prior you being the GSA administrator. This bid process began in 2012, correct?
So the process began in 2008 when the legislation was passed, and the competition took place in 2012. That's when I believe the lease was drafted, and that was signed, and we moved forward from there.
And at that time, President Trump was not even president or even running for president.
No, ma'am.
And that contract or that award of using the lease was awarded prior to that, and he was, might recall that even during the 2016 campaign, nobody brought the issue about this building. Is that correct?
I wasn't party to any conversations about it then. I was working for the Armed Services Committee at that point.
So the employees that usually works with the awarding of these outleases are career employees, correct?
Yes, ma'am.
So this is a regular process that goes on in GSA where regular career employees revise the documents and award whoever is going to be the tenant for these outlays, correct?
All contracting decisions, whether they be leases, outleases, or other contracts, are made by career employees. Yes.
So we can't say that any Trump administration official or political appointee influenced at that time any of the career employees in GSA.
That's correct, and I think if you look at the Inspector General's report, she looked at 16 months and found there was no finding of any political influence being brought to bear.
And just to state a fact, it was approved during the Obama administration,
Yes, ma'am.
so not under the current administration.
Correct.
And as Mr. Palmer and Mr. Pence stated in their opening statements, this committee received information regarding this during that time, and nothing, there was no opposition to the lease at that time, correct?
There was, I'm sorry, I'm not sure I'm understanding the question. I want to make sure I'm precise in
I
answering.
mean, we received notification about the lease, but it was no opposition in the committee at that time.
I wasn't with GSA at the time, but I was unaware. I've never been made aware of any opposition being raised.
So the position begins after the president was inaugurated.
Yes, I believe that's when the,
So it is clear that this is just because it's the Trump Hotel. Are we doing this kind of investigation with any other outleases the GSA have?
not that I'm aware of.
With that, I yield the rest of the time to Mr. Pence if he want to use it. No, with that, I yield back.
Thank you. Let's just be clear that the reason this is an issue is because Mr. Trump is president. If he were still a private businessman, we wouldn't be concerned about emolument. So all this discussion of Obama entering into an agreement when Trump was a private citizen is fairly irrelevant. Well, now, we'll go now to Mr. Garamendi.
Thank you, Madam Chair. That's precisely where I was going to start. This issue is not one of where the lease began. This issue is one of the president of the leasee, Mr. Trump, becoming president, and now in direct violation of the emoluments clause. So my question to you really deals, Administrator Murphy, could you please confirm for the record that the GSA has no idea whatsoever as to how much spending by foreign governments accounts for the income and profits at the Trump Hotel?
That's correct, sir.
So you have no idea about foreign expenditures at the hotel, correct?
The only thing I know is what I've read in the paper.
I'm sorry, the only thing you know
Only I
is...
know is what's been reported in the papers.
I see. Have you ever made an attempt to request information from the Trump Hotel organization regarding foreign spending at the hotel?
No, sir.
Why not?
That's, again, that would be the lease contracting officer's determination. And
I
it's
see.
not within
So
the
it's the
scope of the
contracting
contract.
officer. You were sworn in as an official of the U.S. government?
Yes,
And
sir.
you took an oath of office?
Yes, sir.
Did that oath include upholding the Constitution,
Yes, sir.
including Article 1,
Yes, sir.
Section 9, Paragraph 8, specifically the emoluments clause?
Yes, sir.
So that's included, but yet you've not asked any questions whatsoever from the Trump Hotel organization about foreign spending, which is an emolument.
The emoluments clause has been, issue is being currently litigated in 3 lawsuits I'm aware of. Those were filed before I became the administrator. I believe when there's a
And
disciplinary...
therefore, it's not your responsibility. Is that what you're saying?
I'm saying the Department of Justice has publicly argued that there is not an emoluments clause violation. They speak for the
see.
executive branch on issues of constitutionality. When there's a conflict, it's resolved in the courts. And when there's a final determination of the courts,
Thank you.
GSA will act accordingly.
We understand stonewalling very well around here. Let's see, it says, without the consent of Congress. It was earlier suggested that this committee has no interest. I would suggest that all of us read the emoluments clause, and it says, without the consent of Congress. Has Congress consented to foreign expenditures at the Trump Hotel?
Again, sir, it would be inappropriate for me to say
The answer is
more.
no, we have not. You're aware of that, I suppose. So you're basically saying that in direct contradiction to the Inspector General, you have no interest in determining whether there is foreign expenditure at the hotel?
The Inspector General has not recommended that we undertake any such action. The Inspector General gave us one recommendation, and that was that we prospectively alter the clause in the contract. And we've
Have
done
you
so.
attempted to do that?
Yes, we have agreed to alter the clause, and we now actually use a reference to the underlying statutes instead, sir.
So you have no idea about foreign expenditures. You offered to the committee to show the records. Is that correct?
Yes,
As long as we keep it secret.
Yes, sir.
And you now tell us that those records have there's nothing in that record about foreign expenditures. That is who the guests are at the hotel?
No, those records, it's my understanding, would not include that information. Those records are, financial records we receive from the tenant are those that are required by the lease. They include the audited financial statements. We receive that information. It does not give the level of specificity, though, that I believe you're asking about.
I would suggest that we need to get those records in order to determine if there are indeed foreign expenditures at the hotel, which of course we know there have been. With regard to the lease sale, I want a very specific answer. Are you going to investigate any potential sale of the lease as to whether it is from a foreign entity or a foreign government?
I'm not going to speculate on hypotheticals. I'm going to assess.
That is not a hypothetical. That is a specific question. Are you going to investigate whether the sale of the lease involves a foreign government or a foreign entity?
When we receive, if we receive an offer from the tenant to substitute a qualified transferee, we will do the assessment that is required.
So the answer to my question is no, you will not.
If that is required, that is what we will do. I don't know what the offer is going to be at this time. I don't know if we will
May I
receive an
suggest
offer.
that you carefully read the Constitution of the United States and your oath of office in which you said you would uphold the Constitution, including the emoluments clause. I yield back.
Let's clear up something else. You said that prospectively you have changed this in compliance with the IG's recommendation about emoluments, but let's be clear, didn't you only change it to apply to members of Congress, not to the president or potentially other people who are in government?
So the change that we made was, so that the recommendation from the IG was that we, before continuing to use the language, we determine the purpose of the interested parties provision and act in accordance with that. So the IG, in conducting her own review of the interested parties provision, was also unable to determine exactly why we had that provision in. The best that we had was that it was based on the statutory predecessor to Title 18 and some other statutes. So what GSA did was say that prospectively, we will refer to the statutes that are governing, and if and when there's an additional statute that governs how we deal with these leases, we will amend the lease accordingly.
So you just relied on one statute that mentioned members of Congress as opposed to expanding it to say other members of government?
Correct, ma'am.
Well, I think that's something this committee better clear up so that you won't have any doubt about that going forward. All right, who's next? Mr. Perry.
Thank my friend from the great state of Nevada. Administrator, just out of curiosity, I'm offended. I don't know that you are, but I'm offended for you at the implication, the inference that you're not upholding the oath of office that you've taken. In that regard, do you consider, if the courts don't find in favor of the opinions of some of my colleagues on the other side of the aisle, would you consider that to be stonewalling?
No, sir.
That would be the process, and sometimes we agree with the court's findings, and sometimes we don't as Americans, right?
Yes, sir.
Just, I know you were cut off on numerous occasions when the chairman was asking you questions. and unable to fully complete your answer, I just want to give you the opportunity to do that now. And I with a specific interest in your, if you can remember, the IG recommendations regarding these issues.
So again, the IG gave us one very specific recommendation, and GSA agreed to that recommendation. We've taken the actions in accordance with that recommendation. We read the recommendation as being prospective, and so we have applied it prospectively. And we continue to have a good working relationship with the IG. I meet with her monthly to see how we can better manage GSA.
Administrator, do you think that all Americans, regardless of their stature, financial position, connection to politically powerful people, organizations, institutions, deserve the same standard of treatment under your organization's rules and procedures?
Yes, sir.
So do you believe then that because the old post office is owned by, or leased by the Trump organization, that they should withstand a different set of circumstances than every other American or every other company operating such leases in America?
So, sir, I want to be really careful in answering your question because I think we're starting to conflate two issues, one of the emoluments clause and one of the lease. And as I mentioned earlier, the first lawsuit on the emoluments clause was filed before I ever started at GSA. And then on the lease, our contracting officer determined the tenant was in full compliance with that lease in March of 2017. I didn't become administrator until December of 2017. And when he made that determination, he issued a certificate of estoppel. So my opinion is absolutely irrelevant. I am stopped from taking any action. There's a final decision that's been made. The only time I'm going to have an opportunity to make a decision is if, and again I say if, we receive this qualified transferee. And at that point in time, I'm going to do the right thing.
So just to go back on your own statement there, you said that the organization was in full compliance. Is that correct?
Yes.
In full compliance. So based on that, having no reason to change things, I'm not sure why we're here. I come from South Central Pennsylvania, where the roads are clogged up at 7 o'clock and 5 o'clock in the evening with traffic. We're not, in this committee, Transportation and Infrastructure, people are looking for improvements in their lives, whether it's the road network, water, gas, sewer, broadband, cable. Yet here I sit in another hearing about the old post office in Washington, D.C. Let me just ask you this. Boeing was brought up in the context of this conversation, where Boeing is the subject of scrutiny and investigation regarding the untimely and unfortunate deaths of hundreds of people. Whether they have anything, directly to do with that is yet to be determined, is being determined at this time. Does that have any relevance whatsoever to the issue at hand regarding the old post office in Washington, D.C.?
Not that I'm aware of. GSA
Not that I'm aware of either, ma'am. You said that we are allowed to peruse financial information and records, but not legal records in this instance. Is that different than any other instance in the entire portfolio that you manage?
No, sir, and it's not different than I can't think of any administration that has provided, any GSA administrator who's ever provided those legal memoranda.
So why should what is the reason we would single out this one? What is the reason?
I would defer to the committee to answer that question, sir.
Madam Chair, I yield back the balance.
Thank you. Can you think of any other circumstance where the president has a lease, out-lease, or any kind of lease that would make this like any other lease?
I just get irritated.
Because the president's not involved?
No, ma'am.
No, ma'am. Okay, thank you. All right, Mr. Johnson.
Thank you, Madam Chair. You know, it amazes me how it seems that my friends on the other side of the aisle are willing to compromise their values and their prerogatives as members of the Congress to oversee operations of the executive branch, particularly when it would come to a money-making venture that the President of the United States benefits from. It just, I don't understand why they can't understand the significance of overseeing these types of situations. Maybe it's because everybody likes to go to the Trump Hotel, to the watering hole, and hang out in the Trump lobby with Lev Parnas and everybody else over there. I think he called it a cesspool over there, where you got a bunch of folks trying to get ahead. And it seems like everybody, all of my friends on the other side of this dais want to try to get into the favor of the president. So I probably wouldn't doubt that many of them frequent the Trump bar over there at the hotel. But at any rate, as the administrator of the General Services Administration, Ms. Murphy, you do understand the emoluments clause, the foreign emoluments clause, do you not?
I do, sir. I won't claim to be an expert on it.
Well, you are aware of the fact that the Trump Organization has made plans to sell the Trump International Hotel, and in marketing materials provided by Jones, Lang, and LaSalle, which is their sales agent, the Trump Hotel has admitted that it has experienced only a 57% occupancy this year, which compared to a 75% occupancy rate for competing high-end hotels indicates that the Trump Hotel is not living up to expectations with respect to the leasing of hotel rooms. But do you have any of that information having to do with its banquet facilities, its bars, or other operations?
Sir, I've never looked at the financial records. It's my understanding that they look at how rent is calculated, what the gross receipts are. I don't believe that it goes into the detail, but again, as I've
You don't think that's important from an emoluments standpoint?
From the emolument standpoint, or from a perspective of?
From an emolument standpoint, you are aware of the emoluments clause. You are the administrator of the GSA. You don't take the emoluments clause seriously?
I take the Constitution very seriously, sir, but.
Well, let me ask you
Department of
this. Let
Justice-
me ask you this. Marketing materials from JLL assert that the hotel is, quote, organically positioned to market and solicit foreign government business, end quote, because of its close proximity to the White House. Would you agree with me that a president of the United States of America being positioned to market and solicit foreign government business is precisely what the emoluments clause seeks to avoid?
Sir, given that there is ongoing litigation, which I believe.
Well,
members of
I'm
the
asking you
subcommittee-
for your opinion, since you are aware of the emoluments clause and you understand it.
Given that there's
Isn't that
ongoing
the-
litigation,
isn't
it would
that
be
the-
inappropriate.
Hold
for me
on
to
one
comment.
second, ma'am. Isn't that the exact scenario that the emoluments clause seeks to avoid? Yes or no?
The Department of Justice has stated that there, publicly
Okay, so
argued
you're
that
not
there is
going to
not an
answer
emolument.
that question, okay. All right, so let me ask you this. When the Inspector General, Carol Ochoa appeared before this committee in September of last year, she testified that GSA inappropriately failed to consider the emoluments clause before declaring the Trump International Hotel lease valid in March of 2017. Ms. Ochoa recommended that GSA update their outlease language to avoid concerns of compliance in the future. And GSA has yet to make those amendments. Can you explain to the committee why GSA has resisted implementing the Inspector General's recommendations?
So I'd like to first say that the GSA IG found that the decision to not evaluate the emoluments clause was made by the prior administration. No one in this administration was involved in that decision.
Now, you're not answering the question I just
IG made a
asked.
recommendation, and it was specifically that before continuing to use the language GSA determine the purpose of the interested parties provision, conduct a formal legal review by the Office of General Counsel that includes consideration of the foreign presidential emoluments clauses, and revise the language to avoid ambiguity. GSA agreed that with the single recommendation and said that we will take action consistent with that recommendation.
But you've not
prior to
done so
continuing
yet.
to use the language. And we have modified the language that we will use in future outleases.
You have?
We have.
Okay. All right, thank you. I yield back.
Just to be clear, in September 2019, the IG said that the agency's proposed corrective action is not responsive to the recommendation and therefore considers it an outstanding recommendation. So has this changed since September?
GSA considers that we have taken final corrective action.
They just don't accept it as valid, apparently.
Inspector
Okay,
General does not agree with it.
Thank you, Madam Chairwoman. Ms. Murphy, you said in your opening statement that Dan Matthews, the Commissioner of GSA's Public Building Services, you reminded us that he testified last September and gave us a timeline of the lease of the old post office. And I'd like to go through some of that timeline, even though you didn't dedicate too much of your opening statement to that. I'd like to go through some of that right now. Prior to 2008, the old post office operated at a loss of $6.5 million a year. Is that correct?
Yes, sir.
And in 2008, Washington, D.C. Delegate Norton introduced the Old Post Office Building Redevelopment Act of 2008, directing the GSA to relocate federal tenants there and redevelop the old post office. Is that correct?
Yes, to find a higher and better purpose for the building, I believe.
Higher and better purpose. And then there was a competition in 2011. I believe the president at the time was President Obama. And then in 2012, the Trump Old Post Office LLC was selected as the winner. In other words, under the prior administration, under President Obama, it was determined by the GSA that the highest and best purpose for that building was to lease it to the Trump organization because they were going to invest millions of dollars into the redevelopment of it. Is that correct?
That's my understanding. I was, again, not a GSA official at the time, so.
So in 2013, who was the president?
President Obama.
President Obama. And the lease agreement was executed under President Obama. In 2014, under President Obama and his administration, the GSA delivered exclusive possession of the premises to Trump Old Post Office LLC. In 2016, construction completed and a temporary certificate of occupancy went to the Trump organization. And in October 2016, the hotel officially opened. During that entire time, who was the president?
Barack Obama was the president, sir.
President Barack Obama oversaw all of that and determined that it was the best purpose for that building. I just want to remind folks that we're debating this lease. Is there anything in that lease that was negotiated by Obama that empowers the GSA to go into the finances of the person who or organization that leased the building and demand the things that are demanded today by the other side of the aisle?
GSA has the right to audited statements that we're receiving right now. We have, if we are facing an issue where we're not being paid or the building is, if we feel that there's an issue with compliance, we do have an ability at that point in time to exercise some additional authorities, but we haven't had an issue where we're not being paid our rent or that the building's not being maintained or that we have a concern about the certificate of insurance or any of those types of
So
things.
they're in compliance. So you.
To the best of my knowledge, they are in compliance,
Okay.
yes.
So just quickly, how does the lawsuit right now that's underway constrain what you can do?
So there are 3 lawsuits underway right now, and because the Department of Justice speaks for the executive branch on legal matters, they have been publicly arguing that there is no violation of the emoluments clause. It would be inappropriate for me as the GSA administrator to be opining one way or the other, and that's the Department of Justice's decision to be making those.
And you mentioned there's a estoppel.
So that's all. That is in regards to the lease clause, and that estoppel certificate was issued. It was in March of 2017. that found that the tenant was in compliance with the lease. And so at that point in time, we were stopped from going back and asserting that they are not in compliance with that provision of the lease.
So you're basically doing your job right now as under the constraints that are put on you?
Yes, sir.
Thank you very much. I'm going to yield the remaining minute of my time to Mr. Palmer from Alabama.
I thank the gentleman for yielding. I have a question for Administrator Murphy. If the president has turned over operational control of the Trump organization, then why would the Trump Hotel be required to deny occupancy to a representative of a foreign government? Should the hotel post signs at the doors that says that individuals in service to a foreign government are not welcome here? Should we not allow anyone in service to, say, the government of Mexico or Canada to pay a market rate for a room there? Or should it only be U.S. citizens?
And sir, I apologize, I'm going to have to give you the same answer I'm giving everyone else, which is that it's inappropriate for me to comment on the application of the emoluments clause given the ongoing litigation.
Well, the thing that is going on here that concerns me is that considering the constant badgering about the hotel from my colleagues, the Democrat colleagues, I'm not surprised that the Trump organization wants to get out of the lease. When the contract was negotiated, the lease was negotiated, they did it as a business decision. It was not a political decision. It has become a political football, another opportunity to badger the president, and frankly, and I'm ashamed of how some of the questions have been directed to you that insinuate a lack of character on your part, the badgering of witnesses. And I just finally want to point out that an individual from representing a foreign government staying at the Trump Hotel and paying the market rate is quite different than some things that have happened in the history of this country regarding U.S. officials, such as King Louis XVI giving a portrait of himself that was surrounded by diamonds to Ben Franklin, or the King of Spain giving a horse to John Jay. An individual paying a market rate to stay at the hotel is quite different. And with that, Madam Chairman, I yield back.
Thank you. I don't recall John Jay or Benjamin Franklin ever serving in the White House as president. So we'll now move on to Ms. Fletcher.
Thank you, Chairwoman Titus. Thank you for holding this hearing today, and thank you, Ms. Murphy, for being here to testify. I do want to follow up on this issue because I do think it's important, and my constituents at home expect our government to be efficient, effective, and ethical. And the questions that we're asking in this committee go to all three of those things. And I think that it is certainly the case when we are talking about using or leasing assets that belong to us, the people. And so it's with that in mind that I have some questions for you about the process, and hopefully it will be something constructive where we can talk about what we on this committee can do to help address and alleviate the kinds of issues that we're seeing, the kinds of concerns that we have going forward. And I think that that is the purpose of this hearing. It's very forward-looking. So it's my understanding that you are an acquisitions expert, and so I want to talk a little bit about that because it's my understanding there are multiple layers of rules and regulations that direct GSA's acquisitions of goods, services, and lease space. The FAR is more than 1,000 pages long. It's 50 some odd volumes. The GSA acquisition manual, GSAR, I have the leasing desk guide here. It's a big book. It's almost 900 pages long. There's a lot of guidance when it comes to a lot of things, except it appears for outleasing. And I have a copy of the Outlease Program Guide, which is much smaller than most of the other regulations that you deal with. And it is my understanding that has created some of the problems that we're experiencing now. And so I think it's useful for us to talk about what it is we can do to be helpful. I am correct, am I not, that the FAR, GSAR, and leasing desk guide do not apply to outleases, correct?
The FAR and the FAR does not apply to outleases. It doesn't apply to leasing at all.
Right.
And the GSAR, there are provisions in it that I believe we have written for leasing because it's GSA's manual. Each agency has its own supplement. The leasing guide is for when we're buying, we're leasing space from others, and then outleasing is when obviously we're taking space that is federal space and making it available to others. So they're all very different sets of circumstances.
Sure, but there are extensive regulations in these other contexts that don't apply when it comes to outleasing.
Correct.
And in fact, we have a 90-some-odd page outlease program guide as the guidance here. And it's my understanding, too, when GSA wants to lease something, it comes to us on this committee with a prospectus to approve the lease.
Yes,
Correct.
That's what we do.
But no outleasing comes before this committee.
No, because we're not asking permission to spend taxpayer dollars, authorization for that. We're actually receiving funds in.
But if some of those questions came to this committee, there might be the opportunity to address some of the things that have shown themselves to be challenges. Would you agree with me on that?
I would. I'd want to highlight that the average outlease that GSA does over the course of the outlease is worth less than $250,000. So
Sure.
most of these are very small, so I would be concerned with making it really hard to get that lease on a roof.
Well,
for an antenna on a roof, I was going to say.
No, I appreciate that, and I think that you would agree with me that outleasing an entire historic building, such as the old post office, should be handled differently as outleasing space on a rooftop for an antenna or space in a lobby for a coffee shop, correct?
Yes, and I believe that at Chairman DeFazio's request, GAO looked at our outleasing program about a year ago and came back with some recommendations because there only are about 5 or 6 of these large outleases. And so I would love to have the opportunity to partner with this committee on figuring out how we do a better job of managing those large outleases.
Well, and that anticipates my next question for you, because understanding that you have this background and expertise, can you tell us a little bit of, in preparing for this hearing on outleasing, which I know was not your expertise coming into this, what has surprised you about the process where you think we can make improvements? And kind of coupled with that, will you agree to work with us to craft appropriate and meaningful regulations for outleasing to avoid some of the kinds of issues that we have been discussing, including transparency, reporting, procedures, and forward-looking evaluations? Because I would note, I made a lot of notes all over, and I may have to do some questions for the record, but one of the things that did concern me is that as I read the lease, once there is a proposal for a sale or a transfer, there's 45 days to approve it, which to me means we need a plan in place and the questions identified, such as, is there going to be an analysis of who the purchaser is? Where are we in terms of some of those essential questions? It seems like we do need to do a plan if there's a 45-day turnaround. So tell us your thoughts on what surprised you and then what we can do to work together to craft regulations that will be meaningful.
The first thing that surprised me was, frankly, how small most of these outleases are. The second thing that surprised me is that we don't distinguish between those where we're providing space to a state or local government or an educational institution. So, for example, the University of Massachusetts, it has one of the large outleases, and we don't distinguish between that and an outlease for commercial purposes. I think there are lots of ways. I always would welcome the opportunity to work together with this committee on finding ways that we can be better stewards of taxpayer dollars and of resources. So you've got my commitment that we're happy to work with you on that.
Thank you, and I see I've exceeded my time, so thank you for that, and I yield back.
Thank you. You've got a tough job. Used to work for Mr. Graves, now you work for Mr. Trump. One guy's the show me state, and the other guy's not going to show you nothing. So it's difficult. Several of the people up here have said, well, Obama approved this or Obama's people approved that. You would agree with me, that doesn't necessarily make it the gold standard or right, does it?
I think that they're simply reflecting what happened, sir. So I don't know that there is a gold standard for an outlease along these lines.
Right, so you look at what's right and what's the best thing for the country, and not necessarily Obama did it or Calvin Coolidge did it or whoever. One of the questions that's come up has been the Monaco Hotel. And as I understand it, in the response to the questions we asked of your committee, there is confidential information concerning the lease of the Monaco under the terms and conditions of the lease, and GSO was contracting the officer to see if the tenant would would consent to release the information to the committee. These were in answers to our questions subsequent to the hearing in September. Do you know if the Monaco has responded to your to the contracting officer who requested to release the information to the committee?
So I apologize, sir, I don't know, but I'm happy to look into that and get back to you very quickly.
Sure. Well, that's question number 4. My questions with for that date is toward the end of the questions, and said the GSA contracting officer has requested the tenant's consent to release the information to the committee. Subject to such consent, GSA will forward the lease to the committee under separate cover. So I appreciate your letting me know if they have consented. Okay. Secondly, why is the lease, does the lease have that requirement? A lease is between you and the lessee. Why would a government agency who is responsible to the public and responsible to Congress for oversight of what you're doing in the public, for the public's good, why would you have a confidentiality clause in a lease? Why would you agree to that?
So I can't speak to why anything in 2012 was negotiated the way it was, the terms of the lease. That at least I wasn't party to that discussion.
This is apparently not just this lease, this is apparently all leases. This is referring to the Monaco, and it said it's confidential information or the terms and conditions of the lease. Why would we have confidentiality on any leases?
Because I believe that most companies who are doing business with us are very concerned that others are going to be able to get a competitive advantage by seeing their financial records. And so in order to make sure that we have companies willing to do business with us.
Does the lease have anything about their financial records? The lease, doesn't it just say what they're obligated to pay in rent? And that's public information, is it not?
So and we have disclosed that we're, the amount that we're receiving under the OPO lease at this point in time. I'm not as familiar with the Hotel Monaco lease, but my understanding is that most of our leases, these out leases, do go into, when they're for larger amounts of money, or if there is any calculation that's based on gross, we're going to ask for additional financial information.
In the lease, it asks for additional financial information from the lessee?
In an out lease where there's a base rent or the rent could be based on a percentage of gross, yes, we do ask for, and I know
that's not in the lease. The request for information might be in the lease, or the requirement to disclose, but the data concerning their financial situation's not in the lease.
I'm sorry, the requirement to provide GSA with that data is in the lease. Is that what you're?
Right. This says that
I apologize.
the lease is confidential information under the terms and conditions of the lease, that the lease itself is. Please provide, the question was, please provide the committee with an unredacted copy of the Monaco lease and all accompanying amendments to the lease. And the response was, that's confidential under terms and conditions of the lease. That means that the lease cannot be revealed to the public. That's ridiculous.
And I apologize, sir. I am not familiar with this lease, and I'd be happy to get
If you
back
look
to you.
into it, it's a question number 4. We want to see the lease. We want to see and see why you even make that confidential. You're agreeing to something to keep the public out of it. That's not your job. You should not agree to that. And if a tenant wants to not have the lease be public, there's something wrong with the lease. That's number 1. Number 2, have you looked at the Monaco? They pay more, they pay above the base rent, so you've audited them, or they voluntarily done it. Why have you not audited the Trump Hotel post office like the Monaco has done to pay more than the base lease?
So the decision to conduct an audit would be that of the lease contracting officer.
Excuse me?
That decision would not be a decision that I make, sir. That's a decision the contracting officer makes. And I think that if you all would be willing to come in and take a look at those financial records, I think that a lot of this information would be a lot easier to understand.
If I could just have one last second, Madam Chairman, I would suggest, you said that you would, if it was required, that you would look into the new owners of the hotel and whether they had foreign influence, if it was required. If it's not required, let me suggest you find a way to make it required. You ought to do that if they lease this and sell this. And one other question, the Saudis apparently bought 500 rooms in the hotel. Do you have any basis to believe any of those rooms were even occupied?
I'm not familiar with the day-to-day operations of the hotel.
Well, we ought to look into it, because 57% occupancy, I'd like to know what percentage of the rooms were sold.
and you could sell rooms to anybody, a foreign power, an American group, anybody. The rooms could be sold and not used, and that's a way to provide graft. And that's what the problem is here. It's a emoluments clause, but it's also to make sure they're not just cleaning money or funneling money through room reservations and not using the rooms. I yield back the balance of my time.
Mr. Palmer?
In regard to some of the questions that have been raised, I think there are potentially some constitutional issues here in trying to direct the GSA. And I just want to point out again, as Mr. Massey pointed out, Mr. Perry pointed out, and others, that the contract was negotiated and signed during the Obama administration. And this committee was briefed. There was a 30-day period. The committee was briefed on it. All of the things that the issues that have been raised, the subletting, all of that is in the briefing document. And there were no objections raised by any member of this committee at that time. And I will contend that the only reason that objections are raised now is it's purely political. It has nothing to do with the execution of the contract or the fact that you've gone from losing over $6 million a year to making $3 million a year. It's all political. And make this point too, the old post office lease was submitted to this committee to review pursuant to the authority that the committee has, and there were no objections. That I yield back.
Thank you. And I would point out that Donald Trump was not president when he entered into that lease agreement. I have some questions just to kind of sum up. I don't think you're going to be able to answer them because you haven't so far. But would you find somebody in your office who can explain the lease to us and let us know how much money taxpayers will get if Donald Trump sells the hotel for $500 million as he is asking? Second, we've determined there are very few guidelines for outleasing of major buildings, yet there are a number of guidelines for just the regular leasing process, including one which you failed to acknowledge or pay any attention to when you followed the IG, or allegedly followed the IG's recommendation that you clean up the emoluments clause. And this is one of your conditions of leasing that says no person holding a federally elected office may directly or indirectly participate or benefit from the lease. Why you can have this in your leasing provision but not in your outleasing provision is beyond me, so maybe you could explain that. The third thing I'm curious about, and this was mentioned by Ms. Fletcher, is the 45 days. It took over a year originally with the RFP to come to this lease as it was first written, but now only 45 days. You got no rules, nothing to guide you. Maybe you'll investigate, maybe you'll find out if they're a foreign power, maybe you'll just depend on their self-disclosure, and you're gonna have to do it in just 45 days, which probably is not gonna be enough. But the rest of that clause is what's so interesting, that is if you don't get it done in 45 days, then the Trump organization will just issue a second notice that this is who we're going to sell it to, and transfer of the lease will be deemed approved without any kind of sign-off from the federal government at all. So if you can't get it done in 45 days, they'll just do it automatically. Now, do you want to address those three things? Do you have any way to enlighten us further than what you've done so far, or do you want to take those for the record?
I had 4 down, so maybe I want to make sure that I've got all 3 of them correctly and then get back to you on them, because I, for some reason, have 4 items.
Well, if it's 4, maybe it is 4. Maybe I miscounted. Maybe that was some of my creative math I've been accused of earlier.
So I think your first request is that we work with having someone come in and walk through the terms of the lease and how those provisions work. Of course, we'd be happy.
And how much money will the taxpayers receive if it's sold for the $500 million?
And then the second question you had was about the outleasing versus leasing, and why there's provision in leasing that isn't President Outleasing, am I correct?
Yes,
ma'am?
the provision about the federally elected officials benefiting.
And so I'd be happy to get back to you on it. I believe the reason is that within the last few years, this committee has started including that language in its prospectuses, and so we've been including that in our leases.
That doesn't answer my question of why you wouldn't use this as the guideline for meeting the IG's recommendation as opposed to going back to some statute from many years ago that was just referring to Congress, where we were self-policing.
Because, again, we're using that for all out leasing. So in the current lease that we have, we don't have the ability to go back and change that lease.
I got that, but you told me you had done this prospectively, but you had relied on an old statute that had only mentioned Congress. I'm saying you got this in your leasing provisions that refers to all federal officials. Why didn't you use that as the guideline instead of some old statute you dug up?
Well, I think that they are current statutes that we're using right now, that they are.
Well, this is
Title
current.
18
This
and
is
Title-
current. This is your own rule for leasing.
So let me go out and I
Okay.
can ask my leasing
All right,
officials.
so
on
that's
that.
number 2. What you got for 3?
The 45-day question was what I had.
That's right. How can you get this done in 45 days? It took over a year to do it initially. Now you're going to investigate somebody they're going to sell the lease to in 45 days. And if you don't get it done, then they can just do it anyway.
So we've.
How'd you come up with that provision?
I did not, ma'am. That was included in the lease in 2012, long before I was still working on the House Small Business Committee in 2012.
Well, you think you're going to be able to get it done in 45 days?
If 45 days is what we have, 45 days is what we're going to do, and we're not going to cut corners to do it, though.
Well, that's reassuring. All right, that's 3. What's your 4th?
I'm trying to read my own handwriting on my 4th, ma'am, and
If
I
you can't read it and
apologize.
I can't remember it, then we'll go on to the next person.
Okay.
You good?
Thanks, Madam Chair. So here's just a general question. Is the Constitution, does that trump a statute? I mean,
Yes,
if
sir.
the court finds that a statute is in violation of the Constitution, it goes away, right? I mean, that's a simple question. Yes. Okay, that's the answer. Here. So, in this case, emoluments are applied to members of Congress by a statute. And in this case, emoluments are applied to the President of the United States under the Constitution. So, and we had a discussion earlier about oath of office and that. So here's the issue. There are 2 things that GSA says. The contracting officer says, well, they can't pierce the LLC, and that it's that we don't really know who's the beneficiary. And secondly, the contracting officer says the president wasn't president when he signed the lease. Fair enough, true. And when the Obama administration negotiated the lease, true. And when Congress reviewed the lease, true. There was no question about emoluments by the President of the United States. He wasn't president. Now, on August 2nd, 2017, at the request of the acting commissioner of GSA, Public Building Service, Department of Justice filed a complaint in the U.S. District Court, District of South Carolina, seeking to condemn a leasehold interest in a minor office space owned by, that's my addition, minor, office space owned by Rice REI LLC, because according to the complaint, contracts between members of Congress and the federal government are prohibited, and the lease in question was voided, get this, upon his election and assumption of office. Now we got another guy who was elected. I don't know if your legal opinion says he wasn't, but I think he was elected, and assumed office. But somehow, this is okay. It's in the Constitution. It's not just a statute. And GSA went to court because a member of Congress, a person with a minor lease, had gotten elected and assumed office. Now, why doesn't that apply in this case?
So the statute you're referring to was drafted and it applies specifically to Congress. you're talking about a lease versus an outlease, and you're talking about a case where.
I don't think there's any distinction between leases and outleases.
Well, sir, in a lease, we needed that space. It was an FBI office, if I'm correct, and if I'm recalling correctly. And we could not.
It was leased, and, and you went to court to void the lease. And in this case,
I think we
we don't care. I mean, he's president. We have a secret legal opinion that says it doesn't violate emoluments. Congress can't see it, and this is routine. It was entered into under the Obama administration, so it's all good. This is a remarkable lack of curiosity on the part of GSA. We allow Trump LLC to self-audit, and we have been provided, on those 10,000 pages of documents, you provide us a cover sheet for every self-audit and financial report. The cover sheet with even the name of the person who submitted it redacted. Now, do you think that's forthcoming? Seriously? And that's adequate for our oversight?
Sir, can I address your issue on the legal memos? Because I think you said something that maybe I can clarify without violating the attorney-client concerns we had, which is you suggest that you would like to see how those legal memoranda address the emoluments clause. I have not read those legal memoranda, but my understanding from the IG's report is that those legal memoranda are not about the emoluments clause and do not
They said that you didn't consider the emoluments clause, but the contracting officer said in November in personal correspondence to Ivanka Trump, everything is hunky-dory, this is all a bunch of BS, don't worry about it.
I'm not sure I would agree with that.
That's not exactly a quote, but that's the gist of what the guy said, this professional who's overseeing this lease, who you're not concerned about and is 8 levels down, so you can't direct anything that might say, well, gee, maybe this guy isn't impartial, and maybe we should put someone else in charge of this, especially if we're now looking at bin Salman or Xi Jinping or, one of Putin's cronies leasing this hotel. Thank you, Madam Chair.
I just had one follow-up question that we were chatting about on this 45 days, because it does concern me, and it seems that there's some vagueness in the lease language. So what I see in front of me is that it says if the landlord fails to respond within 45 days of this tenant submitting all necessary qualified transferee information to the landlord, tenant shall provide a second written notice, and then the landlord qualified transferee confirmation shall be deemed given. So it seems to me that there's some uncertainty of what it means to respond, and it certainly seems like we could explore whether a response is simply providing notice of receipt and then implementing a process to thoroughly review and vet and address some of the concerns that have been raised today in terms of security, in terms of the prospective purchasers. So this, I think, is a good area where we could work out a plan, but my concern continues to be waiting to develop that plan until receiving notice. So I would love to get your agreement today that we could work with this committee and with your office to develop a plan to deal with this, whether it happens next month or next year or in 10 years, that we can have a plan going forward that can address some of the concerns with this 45-day provision.
So Congressman, perhaps a good place for us to start would be if we got some of the GSA experts in to meet with you or your staff and discuss what exactly is covered in that Section 15 provision, and what that means, because you're raising some very good questions about that, and I think that would be a great area for us to explore.
I think it would be very useful for us to explore to make sure that the American people are protected when it comes to the potential transfer of this building, and also to put steps in place for any of the other major outlease assets. So I appreciate that, and we will follow up. Thank you very much, and I yield back.
I just have a question for Congresswoman Fletcher. Are you talking about changes to the current contract or to future contracts?
Well, as a lawyer who spent a lot of time interpreting contracts, I think there's some vague language in this contract about what it means to respond, and whether that means a full vetting process within 45 days or simply engaging in a process. So I think if we can work out a process that will address some of the concerns about a transfer, both for this and forward-looking ongoing agreements, I think that that would be very useful for everyone to have that clarity.
Well, the point that I would raise is that the committee's prospectus process is constitutional because it's tied to the need for appropriations. And if you're talking about making changes to a current contract, there'll be an issue with applying it to an outlease because there are no appropriations involved. If you're talking about future contracts, I think that would be appropriate, but
I think the issue here is really dealing with the vagueness in the agreement and making sure that some of the concerns that were raised can be adequately addressed within a 45-day period. And so what is a process upon receiving notice? Certainly acknowledging receipt is important, but this is an area where I think there could be some confusion as to what the obligations are in terms of the receipt and response, and so clarifying that could be useful.
I think that's pretty clear, Ms. Fletcher. You're not changing a contract. You're just clarifying some of the language as guidance for GSA as it evaluates and responds to a prospective sale.
I only
or
have a
lease.
summary of the provision in front of me right now, so I'd want to make sure that, we're talking to our attorneys, and if there is ambiguity in there, let's talk about or if I'm not correctly describing what the provision is, or how that 45-day period governs, that we have that conversation.
Thank you, and we've got the language here in front of us, so I think it's pretty clear that that's needs a little detail put in it, so you can be protected as you move forward, and you'll have guidance from us so we can avoid some of these kind of questions in the future. Any further questions from the subcommittee? Thank you. Seeing none, I will thank you, not each of our witnesses, but you, Ms. Murphy, for being here with us today and for your testimony. It's been very informative and helpful, and we look forward to working with you as we move forward on this. I ask unanimous consent that the record of today's hearing remain open until such time as our witness can provide answers to any of the questions that may have been submitted to you. And I ask unanimous consent that the record remain open for 15 days for any additional comments and information submitted by members or our witness to be included in the record of today's hearing. Without objection, so ordered. If no other members have anything to add, the subcommittee stands adjourned.